Meet this is the Lordship. Lordship, item 16, that day it was heard, Lordship. Lordship, I just have few submissions to make. That those are my anxieties. Lordship will just, they can start, they can do the thing. Lordship will give me 5 minutes after I finish my PIL in court number 2. Lordship. Humble submission.
What do you have to make?
Lordship?
What submission you have to make?
Lordship, the thing is, there was a status quo order in the revenue. Then also the settlement officer settled the case. The patta was given. So, Lordship, if the case goes back again to those people, what they are going to do, I have some reservations. And during the pendency itself,
There is a direction to make an inquiry.
Yes, Lordship. That is what my submission is, Lordship. Let them. I do not have any aid to that because I support the judgment. Let them make the inquiry. But Lordship will. It will be under monitoring of the High Court, Lordship. Then again, it can come back.
No, if anybody is aggrieved by such actions, obviously they are at liberty to resort to such action as per law.
I understand, Lordship. But then, Lordship, again from 2003, the case is 20 years, Lordship. So 6 months time, Lordship, or 3 months, Lordship can give 3 months time. So, Lordship.
By that time, I think by the time I deliver the judgment, you will be back.
Yes. Highly obliged.
Make please, Lordship. Lordship, with the concern of the other side, I beg to mention item number 5, Lordship. Lordship, my senior is out of station. So next week, any date may.
The request of the learned counsel for the petitioner matters that adjourned to be listed after 4 weeks. That is that case, no? That from number 2.
Yes. I don't want to object because the senior is out of station. Because it is substantially hard.
No, I remember this matter. What remains now? Only that I have asked you to file some affidavit.
Yeah, I filed it. The railways were incurring losses, my lord.
So when can we have it? I think this matter needs to be disposed of.
Learned senior calling Mr. D. Mojunda, he has difficulty on 15th and 20th, otherwise any date.
The request of the learned counsel for the petitioner matter stand adjourned listed again on 21st. Make clear no further adjournment shall be granted in the fact. Yes, next.
Please, madam. Item number 2. I'm waiting for the respondent number 4, madam. I've been directed to produce a copy of the FIR, madam. I procured it. I'll be filing an additional affidavit today. You may be allowed to bring that on record.
You have filed the additional affidavit?
My lord, additional affidavit, I'll be filing it now, madam. Because the other side counsel is not, I'm not able to, he's come on his way. Get the signature.
We'll have it on the next date, then next week.
Lord, should I appear for the affidavit? You cannot, sir.
We'll have it on 14th. We'll have it on 14th.
14th, my lord, I have some difficulty, my lord.
You can't say that you have difficulty. Because of you, this has happened.
Well, can it be on next day, my lord? That is on 15th, my lord. 15th,
Can't be at your convenience. Or we will take it as if you have not filed any. What do you want?
It can be taken today also. I'll be filing it, my lord, and I'll be bringing it on record.
Bring it.
Okay. Sorry, madam. There is a case item number 7, my lord. I was given this affidavit in opposition. I made it prepared today. I will supply to my friend. So will they come on Friday or next Thursday?
I have not yet received the affidavit, but I take his words for it.
CMC I have given
Next week, my lord, on Tuesday.
Any stay operating?
No stay.
We'll have it after vacation.
Thursday,
After vacation.
They will serve the affidavit.
I will send
They will serve the affidavit.
No, we can't have it at all. I have given you time to file it. But
and we filed the affidavit in.
Supply is 13, but they have given us 18, my lord. And
No.
after that, 18, I receive 18. 17 or I receive 18.
17.
So 19 is vacation. I prepared to. But direction was 13.
won't open today. This matter on. It's not part of
No.
Is this matter on 5th of December?
Then my lord, when later let me matter the time.
Let the matter be listed on 5th of December.
5th of December.
I have some
The
urgency,
request
but
of the Learned Council.
Fine.
As the Learned Council, Mr. M.J. Borwa, the Learned Council for the petitioner submits that he is in the process of filing some affidavit in the matter. Taking into account the above, list the matter again on 5th of December. Okay. Yes, Mr. Mahmood.
My lord, matter was yesterday mentioned before court number 2. It is a very urgent matter, that's why it was permitted to be listed today, but not this day. Now it is told that the matter of court number 2 shall be maybe mentioned in this court. So it may kindly be taken today as unlisted matter.
What is that
Yes.
matter about?
SMC, my lord. Earlier, the SMC,
What is that?
School Management Committee of LP School, that was, my lord, dissolved by the DO. Again, the same committee has been sought to be restored due to unknown reason.
You want to move it unlisted?
My lord.
You want to move it today?
Unlisted.
Today?
Today, yes.
What is
because
the urgency to-
If the illegal committee is approved, then the purpose would be vitiated.
No, what is the urgency that the matter
Urgency
needs
means
to be moved?
earlier the DO dissolved the SMC on the ground that rule was not followed. Departmental representative was not there, so that was dissolved. Now again, an imaginary committee has been constructed.
I understand everything, but thing is, why is it required to be moved today? Can't it be moved tomorrow? Can't it be moved tomorrow?
Tomorrow, my lord, I may not.
Huh?
Tomorrow, I may not.
Oh, there's a council's difficulty. We'll have it on, then we can wait till Monday, Tuesday, Wednesday. Why should this court
Then let it be tomorrow, my lord. I will
tomorrow?
try.
Supplementary item number 16 and 17.
Oh, it is, huh? Photo pen. Photo pen. Move them to you. Yes.
Maybe.
Yes,
Lordship, here, in the present case, Lordship,
you were supposed to show me judgment.
I
Show
have
me.
on that point, I am submitting.
Hmm.
Lordship, the revenue authorities officer, that is the ASO or SO or the or board of revenue. Under the Assam Land Revenue Regulation, they have only power to decide dispute regarding position. Regarding position only. And beyond position, if there is any other dispute, party must go to the civil court law. That is the provisions of the Order 41 of the regulation.
Yes,
First of all, your Lordship, me please to peruse the regulation number 4040. The settlement officer shall frame for each state a record of rights in the prescribed manner. The record of notice, the record of rights is in the Jamamandi based on the Chitas and the field map 41. Entries in record and their effect. Entries in the record made under section 40 shall be founded on the basis of the actual position and shall all dispute regarding such entries, whether taken up by the SO or his own motion or on the application of a party concerned shall be investigated and decided by him on that basis, and all persons not in possession but claiming the right to be so shall be referred to him to the proper court. Which means, Lordship, if there is other dispute except the possession, Lordship, then the matter will be referred to parties to go to the civil court, Lordship. The revenue authorities, including the Board of Revenue, does not have any power. And then, Lordship, in support of my contention, there are few judgments of our own High Court, Lordship. Citation is, Lordship, 1990, 1 GLJ, page 304, which laid down the law, Lordship, that the section 40, that is regulation 41, ASO Board of Revenue have power to consider possession, and possession alone can be determined. When the issue as to title arises, the authority has to refer the parties to the civil court. Refer the parties to the civil court law. Para, Lordship, para, third para. Second page, third para.
Yes.
Yes. Next citation is, Lordship, our own High Court judgment. AIR 1967, Assam and Nagaland, page 3, Lordship. Para 6, 7, and 8. Where, Lordship, here in the impugned order, the chairman of the Board of Revenue has given a direction to the DC to cancel the patta, which power is not given to the Board of Revenue or to DC or any other revenue authorities, Lordship. Even the commissioner of the division does not have the power to cancel the patta once it is issued. If there is any aggrieved party, Lordship, he should go to the civil court for adjudication of his right that the patta was wrongly issued. That question cannot be decided by the revenue authorities, Lordship. On this point, our 1967 Assam and Nagaland, page 3, para 6, 7, and 8. Lordship, may we please to come to the para 6, Lordship. Sub-para 3, Lordship. The plain reading of Rule 26.
Yes.
Next citation is Lordship. Supreme Court Lordship. Here, your Lordship, is pleased to note that the patta was issued to the petitioner's Lordship in the year 1990. And the respondent number 3 Lordship, who filed the appeal before the Board of, filed the appeal in 2003. After 11 years, 2 months, along with a condonation. And that condonation petition was allowed by one of the members of the board, Mr. T. Chaikia, Lordship, without issuing notice to the present petitioner. So, Lordship, the apex court in EIR 1995 ST 1010, para 4, Lordship, held that if any petition or patta is granted and if the appeal has been filed after a long gap, it cannot be entertained. That is para 4.
Yes.
Next citation is Lordship. Lordship 99, 1 JLR, page 229, para 7. Here our Honorable High Court laid down the law, Lordship, that the petition in this cannot be brushed aside and must receive due consideration by the court. Patta holder is deemed to be a landholder and has a permanent heritable and transferable right of use and occupancy in his land subject to Section 9 of the Assam Land Revenue Regulation. Patta must be considered to be a document of the title according to Section 70. Records of rights shall always be deemed to be correct unless contrary is proved.
Yes, Mr. Roy. None of the judgment has any applicable. Tell me.
No, that I leave to your law.
Anything else?
Yes.
Yes.
Lordship, other citation is 2009 4 GLT 6 para 7. 2009 4 G. Here, Lordship, para 7, this honorable court held that there is no provision for the cancellation of the patta in the ALR.
Para 7.
Para second page, Lordship, after. Para 7, last portion, Lordship. In support of the aforesaid contention, he relied on a decision in the case of so and so, wherein the Honorable Chief Justice Adani, while accepting the submission of the learned practice of the respondent of that case, stated that. And in that observation, Lordship, last line, patta cannot be kept. DC does not have any.
Yes.
Next is Lordship 2002 CGLR what? Para Lordship 6, where it has been held by this Honorable Court Lordship that when field index is prepared and when the chitta is prepared, Lordship, on the basis of the actual position of the land, Lordship, then there is a presumption regarding the position in favor of the recorded patta unless repeated. Here, no, there is no repeatal by the respondent number 3, and there is no dispute regarding between the petitioner and the respondent number 3 who filed the revenue appeal law, because already the petitioner number 1 has given it there to the respondent number 3, that is the appellant for the, and that is admitted position regarding that. I had also filed the deed of lease by which the respondent number 3 leased out the portion of his land and house to one Ratul Talukdar. And apart from surprising thing in this case, Lordship, the appeal was filed. No impugned order was. I have taken the preliminary objection that impugned order has not filed along with the memo appeal. I have annexed the entire order sheet of the Board of Revenue, Lordship, which will show that the records from the office of the DC or settlement officer were called for. And it took, Lordship, almost 2-3 years. Thereafter, Lordship, the settlement officer sent a letter to the Board of Revenue that the regarding settlement operation file is not found. But he sent a para-wise comment to the Board of Revenue, Lord. My interesting point is this, Lordship, when the record is not found of the settlement operation, on what basis the settlement officer has prepared a comment and sent to the Board of Revenue, Lordship? Lordship, I may be pleased to peruse the order.
Mr. Roy, what is the wrong in the direction?
Direction is wrong is, Lordship, the Board of Revenue passed the order directing the DC, Lordship, to cancel the patta, number 1. Number 2, file civil.
So what was the power exercised by the Board of Revenue?
Pardon.
Was the power exercised by the Board of Revenue is in the as an administrative side, or was it on the judicial side?
Board of Revenue, Lordship, passes order, Lordship may say, as a quasi-judicial authority.
It
Or-
passed the order in the judicial side, not on the administrative side. The judgments which you have been placing out here regarding Rule 26. Rule 26 is the power exercised by the commissioner on the administrative side. That is, in that very judgment, if it is say, it has been stated that if an appeal arises out there under 147A and exercised by the commissioner, then he can very well do it, being on the judicial side.
No, here interesting thing is this, Lordship, when the DC does not have the power
The
have-
question before this court is this. The facts which was before the board showed that on one hand you were in possession of 1 katha 13 lectures of land. Why? You were given a patta of 2 katha 16 lectures. An inquiry was directed to be conducted.
Lordship,
So what is wrong with that order?
day before yesterday, I have placed you, Lordship, the rules framed under the settlement.
That rules are not applicable. That rules has no value. That rules are only as regard, just for example, if during a
total-
settlement operation out there, a person is found is in
Lord,
possession out there.
The
The
total-
patta is not issued on the basis thereof. He may at best be used or mentioned as a dakholkar. That's all. Nothing more than that. A person does not get a right on the basis of a possession. See Rule 16. See Rule 15. Rule 15 of the settlement rules
Some difference
categorically
in this law.
mentions that.
A patta was issued rightly or wrongly during the settlement operation.
Obviously, that patta can very well be touched by the revenue board under 151. That power, the revenue board has it.
My
And what the
submission is-
revenue board has
my-
asked
My submission
to
is
make a to make an inquiry into that aspect.
that Lordship, the impugned order is totally confused order, Lord, because the learned chairman.
I am not finding it confused. You are
No, no,
finding it confused for reasons.
One instance I'd
you
like
know.
to point before your Lordship. Finding is this, that earlier it was a Lakhiraj land belonging to the Kamakya temple as a devotional property. That land was acquired under the provisions of Act of 1959, Acquisition of the Assam Religious Property, Public Nature Act 1959. And chairman observed that it cannot be. Lordship, when the land was Lakhiraj, revenue free, and it cannot belong to the devoter. That is the finding of the chairman.
No, it is not that finding. It says that on one hand, the reports show that it is a Lakhira's land. And on the other hand, there are certain pleadings out there to the effect that an annual patta has been issued to you. How can both correlate? That is what has
Lordship,
been
that
finding
is
out there by the
Lordship.
Board of Revenue.
Originally, it was a Lakhiraj land. When it was required, it was converted into annual patta, Lordship. Then, Lordship, it was during settlement operation, Lordship, it was converted to KP patta, Lordship. But see the findings of the land chairman.
That I have seen it.
That
There's nothing wrong out there.
Because Lordship, at that time, the chairman was one Karelian person, Mr. Kerry. And he was not aware.
Mr. Roy,
local law.
kindly don't make all this type of submissions. That he is a Karelian person,
No,
he is
that is not
he is from the,
I have
he
to
may
admit,
know.
He was not aware of the local law.
Why is it
That is-
necessary? A local law is known by a person on the basis of reading the law, not on the basis that he belongs to some other community or some other place.
And regarding condonation, Lordship, I would like to place some judgment because the appeal was filed after 11 years, 2 months. Lordship, the first citation is Lordship 2007 2 SCC 322, para 5. Para 5, Lordship, it laid down the law that the delay cannot be condoned merely on the sympathetic ground when mandatory provisions not complied with and delay not.
Whereas section 5 applicable
Lordship.
in
No,
the
here
land revenue
148.
under the Assam before the
Pretty
Board of
same,
Revenue.
No, no. For limitation before the Board of Revenue, for limitation is under section 148.
But tell me whether if there are plenty of judgments of our division bench of the High Court to that effect that if a power is being exercised under 151, then obviously the question of limitation doesn't arise.
Lordship, when the appeal was moved as a motion, Lordship, appeal was admitted and delay was confirmed without issuing notice to the petition.
Are you saying that? Kindly read paragraph page 215 of the judgment.
Para?
You have filed your objection. Page
I have
215.
filed subsequently.
No. Kindly
Lord-
see the appeal was
Lordship,
listed
I have-
again on for
I have
disposal of other
annexed the
objection.
entire order.
As neither side was on so and so, the learned counsel has sought last chance for a year. This was allowed and appeal was listed here for hearing of all objection, and having heard the so and so all objection, reasons of the same was recorded in here. The next date was fixed and so and so. It has been categorically said whether the first came up before demand and the rear wanted to file against the period petition for condonation of delay. The matter was taken up next when the learned counsel for the respondent, after great reluctance, agreed to present his case on the issue of limitation only. As the learned counsel for the appellant appeared late and sought to file written arguments on so and so was fixed for deciding the issue of condonation of delay, as the learned counsel had been insisting that this should be taken up first before going into the merit. The matter was taken up on 16/8, wherein the delay was condoned. Then you filed your
It is a
objection. You have
subsequent
been
event,
very well
Lordship.
present out there in the court, and this is what has been
See
recorded.
their condonation petition.
Huh?
Please see the condonation
Yes.
petition filed by the respondent number.
I'm not
3.
going to look into this. This is what has been obviously observed by the court. That was on 16/8/2010. What is wrong?
Lordship, without having the records of the settlement operation.
Is it
without-
required?
without-
For condoning the delay, is it required for that?
No. I
Then-
am arguing on the main.
Again, you are coming back to the merits
Lord-
after that.
Lordship, there was no record before the Board of Revenue of the DC Office of Settlement Office, Lordship. Impugned order was not annexed to the memo appeal. And even in the appeal has been, I have taken the objection in my objection, Lordship, that the appeal is not maintainable as because Lordship may face to peruse the entire order sheet I see the conduct of the respondent number 3, Lord. Yes, page 67. Page 67, Lordship. First, 9/10/2002. Since the memo appeal under section so and so of the LR filed against the memo number so and so by the ADC Kamrup, the learned advocate of the appellant perused the petition for condonation of delay. It appears that the appeal has been filed against the memo number so and so above issued by the ADC Kamrup to a special commissioner, secretary and revenue department, government of Assam. Hence, I feel it necessary to call for the relevant record and report on the memo of appeal before passing any order on the point of the maintainability of the appeal. Call for the record and report accordingly, fixing so and so. Then, Lordship, see, Lordship, next page, from 2002 to 3, then Lordship up to 4, next page 2004, then Lordship 2004, next page Lordship 2004, then up to Lordship may come to page 72, order dated 2105. 28/1 record and report as called for not received. Await till so and so. Then also next date record and report not received up to 2005. Then Lordship record not received. Next page 2005 record not received. Then Lordship not received 2005, next page 74. Then Lordship record and received not received 2006. Then Lordship see the page 76 Lordship of 2006. This I would like to replace before your Lord. Learned advocate for the appellant is present. Record and reports are not received as called for from the DC Kamrup. No intimation is also made. It appears that the record and report called are not received. Despite this for reminder dated so and so many reminders were. It also appears that the aforesaid reminder, if it has along with along it is not clear in my copy stated following comply with the order of the Board of Revenue. Contempt proceeding will initiate against the Deputy Commissioner Kamrup M as per the law. Hence, issue notice to the Deputy Commissioner Kamrup by name with a copy of this order stating and failing to send the record and report as called for. Yes, positively or not before. Necessary contempt proceeding will be started as per the law for neglecting and in disobeying the record order mentioned above without issuing further notice. Learned advocate for the appellant has submitted that the board is matter is pending for a long time. Non-receipt of the record and report and the DC Kamrup and the as such appellant has to face the most trouble fault of the others, and as such the appeal should be admitted on the basis of the documents available with the case record without waiting for the record from the DC office Kamrup. After hearing the learned counsel advocate, the appeal is being going through the enclosed with the memo appeal. I am satisfied that the prima facie there is a sufficient ground for admitting the appeal, and the appeal is admitted. Without condoning delay, Lordship, that I had submitted. The appeal was admitted, Lord. Without having the record, without having the without filing the memo of impugned order, Lordship, challenges the memo appeal. And the respondent number 3 has not challenged the patta of the petitioner issued during the settlement operation. He has challenged the earlier order by which the DC has recommended for the settlement of the entire judgment of the Board of Revenue is based on the application which was filed by the petitioner for the settlement of the land before the DC Lord, before issuance of patta. That upon that the chairman has relied. Absolutely perverse finding, perverse act.
Why is the second writ petition filed?
Second petition, Lordship, one of the sister of the petitioner as well as the respondent number 3 who filed the appeal before the Board of Revenue. He filed an application because he is also one of the legal heirs of Jogbala Majumdar, the mother, and own sister of the petition number 1 and the respondent number 3. So she also claimed her share.
And what is the order passed there? 14-3.
Order passed there in Lordship.
Who is paying for that?
No, that is not relating to that. That is a contempt order. A of fine of 2,000 was imposed on him. The order is at page 253, annex 40. Last. It's part 38. That's the provision. You have a position and are opposite that there is of contempt of the board and his liability, but it's because there was a status quo order and he made construction on. So, Minister respondent number 2 is punished with a fine of 2,000 only as that got it by the fine in the order.
Now, have you challenged the order of 16-8-2010?
16,
8-2010?
Board of Revenue.
No, you have not.
I have challenged.
You have not. So the
16,
question of limitation cannot be gone into.
16.8 Lordship. Let me,
You have not challenged.
let me check.
No, your prayer is at page number 35. You have only challenged 16-9. So the question of limitation need not be gone into.
Leave to your Lord.
Yeah.
But the way Lordship the appeal has been disposed of without having the impugned copy of the impugned order.
Now, are you saying that if what is the case of the respondent number 3? The respondent number 3's case is respondent number 3 along with the heir have been all along with Jogabala Majumdar and you have been all along in possession of 3 kathas, 5 lessons of land. And there has been payment of rent, payment of revenue to the authorities concerned. That is okay. One fine day, the deputy commissioner not only gives you 5 lessons of land, but in addition to that, the land which was also the mother's land was also made in your favor.
Joint patta.
Joint has been given in your name, the entire. So that is why the petition respondent number 3 has approached the authority concerned and challenged it. So against that, issuance of the patta, an appeal lies,
No, Lordship. That is not correct.
but is not correct.
Because the Jogbala Majumdar and Dilip Kumar Majumdar, petitioner number, first of all, they had applied before the DC Council for the settlement of the land measuring 1 katha, 3 out and 5 acres. That recommendation was sent by the DC Council to the Revenue Secretary, recommending for the issuance of the patta. But it was never issued, it was never considered. And even no information was given whether it is allowed or it is rejected. Then thereafter, Lordship, the settlement operation started and it ended in December.
So against an order by which order or any settlement being been made by the settlement officer, what is the recourse?
Recourse is, Lordship, they should file the patta, Lordship, they should challenge civil suit, Lordship, because
Why should they go for the civil suit?
Lordship, civil suit is barred, and already I have placed before Lordship the regulation 40 and 41.
40 and 41 is on a different aspect. 40 and 41 has no relevance out here.
Need to consider that
Mr. Roy,
they-
kindly come back to the point which I am asking you.
Yes.
What is the course left when the settlement officer, during the settlement operation,
Hmm.
grants a patta illegally to a person?
Only according to me, Lordship, and as per the provisions contained in the land revenue regulation, Lordship, the aggrieved parties should file a civil, and they had filed the civil suit, which was dismissed. Lordship, just to harass, as because the respondent number 3 wife is.
Are you saying that they filed a civil suit challenging the patta?
They had filed the civil suit, Lordship, I have an expectation.
Have they filed a civil suit challenging the patta?
No.
What they have did?
Regarding that, Lordship, I have an okay. Affidavit. Yes, sir, it is. Lordship, in WPC number 6395, I have filed an additional affidavit. Lordship, make be pleased to take up and come page 7. Yes, they have challenged the part.
What
But
happened there?
No, Lordship, if I may
It was
submit, this is
dismissed.
of a different plot of land.
It was
Lordship, if you
dismissed.
Page 7, Prasanna Kumar, this is a different plot of land. Because this land is also part of that field. He is misleading the court.
Not misleading,
significance-
Lordship. Pathetic
no
thing is this. My learned friend is the wife of the respondent number 3, and personally she has been conducting the cases, violating the Advocates Act and the ethics, and not permissible. Lord.
Outrage. Lordship will peruse page 7. What he is referring, it is against Anjali Majumdar. That is a different plot of land, totally different plot of land. We try to
A plot of
confuse them.
land is
And
different.
just because
No, I am admitting that plot of land is different.
What?
Plot of land.
Then why you mention saying about that the suit has been filed?
Yes.
How is that suit has any relevance?
In the same way, Lordship, the respondent number 3 were at liberty to file a civil suit.
That is a different thing. But why you are mentioning that they have filed a civil suit challenging the patta?
That was not.
and
Then
order was passed, Lordship, that we should approach revenue board, and we approached revenue board. It is case. It was not dismissed. The plaint was
And Lordship, maybe please to come to
and
about-
that suit was held to be barred in view of under Order 7, Rule 11.
Yes.
And
we
accordingly,
filed-
the plaint was rejected.
and we filed a revenue board against that. And
I have
that is a
annexed the
totally
judgment.
different-
I have annexed the judgment.
That is no way related to this.
So, Leho,
Just one thing I would like.
no more.
Lordship, I need to take up.
Yes, what else?
Lordship. Again and again, Mr. Senior Advocate is saying that the patta was granted. Lordship, Jogobala Majumdar died on 16/1/96. Patta was given on 4/1/99 based on their it is their document. How does then again a patta was given, that is Annexure 21, page 157 to 159, patta given on 17/7/2009. He was already dead. How the patta, as per he's saying that
Where is the patta? Where is the patta?
this is finding the patta 150, page 150, patta.
Patta, forget about the patta. What is this? Patta is at page 160.
156,
Timothy
157.
Jokupala Mujumdar. Yes. It was given on in respect to, we are concerned with which task?
489, Lordship.
4,
In the Pata news actually,
this patta doesn't have 489.
no. And this was never challenged.
Now this patta, this patta which has been issued, yes, that's
But from that interesting thing is Lordship, the
where
respondent
is,
number
where is the patta number 49?
One 157, Lordship.
Huh?
The type of the access
Patta
copy.
number 49 is at page 150.
page 157.
57. This one, this is Ketchapatta 156.
156, 155 to 156 is the Kachapata. Kachapata is also a valid
But
title.
here, where is 489? Finally come to page 161. Where is 489? Huh?
Lordship,
489 is not.
we have not mentioned the
No, here the this you are asking for cancellation of which patta? The entire 49.
no cancel the patta number is created by original tag number 391 rather. After that, Lordship, these developments are after that.
No.
These patta
Your appeal which has been filed
Yes.
is challenging which patta?
Here, Lordship, I have
Yes, you say na where Iman of dag number 489.
489.
Patta number 49. 49.
New Pata is Lordship, Pata number Lordship is 199.
Huh?
Page 157.
159.
157.
157 is a kacha patta.
No, Lord, it is a Pata. Kachapata is a page Lordship.
157 is what is the patta number here?
So these were given 199. The
Patta number is 199.
Those
Right.
were
We are
given-
not concerned with 199. Are we concerned with the
Yes, yes, Lordship, because Lordship will Perus 157 and Lecture 21, Lordship. Here, the owner of the land, Lordship, Srimati Jogopala Majumdar, wife of late Narendra Kumar, was Dilip Kumar Majumdar. The owner of the land prayed for patta making. On this date, Lordship, 2009, how he can file a, he can pray for a patta? They are showing that these pattas are given to them. How can she? She died in 96.
Lordship settlement operation
Lordship,
it takes 5 to 6 years, Lordship. At least Kachapata Valley, it was issued, she was alive.
The Miss case was filed in 1992-93.
mistake. Yes.
So Miss case, it is on the basis of the Miss case. Jogabala Majumdar in Miss case number so and so by an order dated 28/9/92. By this order, periodic patta number 49 of so and so was issued for the land measuring 2 bighas, 2 kathas, 6 lechas. So we are concerned with the order of 28/9/92,
Yes.
which was the
What-
order by which the patta was issued.
Yes, I'll give the background for that also, Lordship. What happened? Railways were giving notice. The estate officer railways were giving notices to Jogabala Majumdar and others who were there. And against that, one appeal was filed, which was misappeal. I have annexed in my affidavit, Lordship, page 22, annexure E, 28. There, two appeals were filed, misappeal 5 and 6. And order in that was passed on 19/3/81. And by that, it was directed that the state government will survey the land, and accordingly, the survey was done. And that is the survey which I have submitted in Annexes G, page 31, by which the miss case order 492/93, 28/9/92, which was passed. And how it can be joined, Lordship? If he was at that point of time, he was having 5 letter and she was having 1 kata 8 letter, how it can be joined and then made 2 kata 16 letter or whatever, Lordship, or 13 letter, many.
Lordship, when
And
the
a
new
dead
patta,
person, Lordship?
new patta was not challenged, how the Board of Revenue can adjudicate law, which was not the subject matter 44.
And I would like to submit a few citations, Lordship, on fraud.
And no copy of the affidavit opposition has been furnished to me.
Sorry?
No copy.
Of?
No copy has been, my learned friend submitted, no, she has filed affidavit in office.
Huh.
From my record, that is not available in. whether it
Was
is-
your junior RPN Singh, was your junior on 21/1/2011?
If it is, then I acknowledge.
Then don't make these submissions.
No, I don't have the copy.
No,
How
you
can
don't
you
have
do-
it is a different thing. Kindly don't make these type
No,
of
no,
submissions.
Lordship, I don't have the
It
copy. in
doesn't
my
look
affidavit.
nice.
So my learned.
You when you make a submission, you have to be responsible. You
No,
can't make a
correct.
submission. I have not been served a copy. You may not have a copy with you. It's a different aspect of the matter.
I have
But
not.
don't say that you have not been served a copy.
Sorry.
It puts me in a difficult position.
Lordship, here my submission is this, that the new patta number 198 was never challenged before the Board of Revenue. And the entire judgment, impugned judgment is based on the proceedings of 92/92 by which the settlement recommendation was forwarded by the DC Lordship. Surprising things are these laws. And the patta has not been challenged.
But Patta has not been challenged. It has been all along challenged. If I'm not wrong, what is wrong in my reading out here? Here the prayer, see, so and so, setting aside the impugned order for settlement in the name of the respondent and the subsequent action arising out of order of settlement in the name of the respondent number 2. Then the Patta is there.
Lordship, may I please to peruse the memo appeal.
That is the memo of appeal. I am reading the memo of appeal.
But
It has
the
been
judgment-
categorically mentioned. Order passed by the respondent number 1 for grant of Patta in the name of so and so. The case on the date of passing and so under section here that is to set aside and quash the impugned order of settlement dated so and so by which Miyadi Patta number 49 so and so for a plot of land was settled in favor of them. That is the challenge which has
Patta
been
number
mentioned.
49, not patta number 199.
No, it is only Patta number 49.
Yes.
Patta and because Patta number 199 does not have dark number 498.
Lordship, from the old DAG number 489, new DAG were created. It is always created under the settlement operation. Patta number and DAG number changes.
Are you saying that there is no periodic Patta number 49?
There is periodic patta number 49, Lordship.
Are you saying that? Because that is the reason why at page 156, 157, 160, I don't see dark number 498 or 89 even.
No, Lordship.
489.
No,
Dark
Lordship,
number
I just-
489 is not there. On the other hand, dark number 484 is there, the last of the darks. Are you saying that dark number 190, Patta number 199, she has not challenged?
Yes.
She had only challenged Patta number 49.
Lordship, after issuance of a new patta, press right was given.
Are you saying that after 199, again another Patta was issued, Patta number 49?
No.
Then-
Last patta is 119.
So here the order which have been passed is only in aspect of dark number, Patta number 49.
Lordship, the surprising thing is this, the order passed by the learned chairman, Lordship, that states regarding entire fact is based on the basis of the recommendation of the DC, which was sent by
Mr.
DC.
Roy, kindly make it clear whether it is dark number 1, Patta number 199 or Patta number 49.
Lordship,
In the
49,
memo appeal, Lordship, page
became
37,
199. That is what is the thing.
page
How do you
30,
say so?
page
Because Lordship, that was the recommendation, and thereafter the settlement was made. That is why is the fraud, Lordship. That is why the learned chairman has observed that way, Lordship, in the judgment.
Let us read from page 216.
Yes.
Let us read why the court has found.
Yes, Lordship.
Page 200, because the
Yes.
earlier portion is as regards limitation.
Yes.
Yes, Mr. Roy, take your seat. Yes, Madam,
Yes, Lordship.
read it.
I'll start.
So far as the merits,
So far as the merits of the appeal are concerned, the appellant has preferred this appeal against the grant of Patla jointly in the name of Srimati Jogobala Majumdar and Sri Dilip Majumdar in Miss Case number 4 in 1992-93 by an order dated 28/9/22. By this order, periodic Patta number 49 in tag number 498 of village Maligaon Moja Jalukbari, Guwahati was issued for land measuring 2 Katha 6 Plesa in favor of Srimati Jogobala Majumdar and Sri Dilip Majumdar jointly. The appellant and respondent number 2 and 3 are siblings. The case of the appellant is that he, along with his mother and others, were occupying a plot of land measuring 2 Katha 6 Plesa covered by DAG number 489 for more than 50 years by constructing an Assam type house. The mother of the appellant applied for settlement of the said land and a proposal to this effect was forwarded to the government. The mother of the appellant died on 16/1/96. This is to be noted, Lordship. Left behind 6 sons and 2 daughters. The respondent number 2 is the eldest son, while the appellant is the youngest. In August 20,
respondent number 2 is the
eldest
eldest son and the appellant is the younger. You are the youngest.
youngest.
Okay.
Because, Lordship, why it happened? There was a bill left
No,
behind.
forget about. Don't bring the weight.
No,
No.
I'm not bringing up
Yeah.
why we
Don't.
had to take.
Yes.
In
and-
August 2003, the appellant came to know that the respondent number 2 has filed a missed case before the assistant settlement officer. From this, he came to know that the respondent number 2 has got his name entered as a joint pattadar along with their late mother, Srimati Jogobala Majumdar. On checking details, he got to know that the respondent number 2 has got the new patta in 1992 jointly with his mother through the respondent number 2. Though the respondent number 2 was not the only legal heir in possession of the said land. The appellant claims that the settlement should have been in the name of the mother late Jogobala Majumdar in respect of the land in question, and it should not have been jointly with respondent number 2. The respondent number 2 in his affidavit in opposition to the memo of appeal has stated that after getting settlement of the land in the joint names of Srimati Jogobala Majumdar and the respondent number 2, the entire land has been settled amicably among the legal heirs of late Jogobala Majumdar, and appellant has got his share of the said land. During the current settlement operation of the Jalukbari Moja, separate DAGs have been created for the shares of the legal heir of late Jogobala Majumdar. But this is not as per the documents. The respondent number 2 claims that appellant had full knowledge and information regarding the settlement of the said government land in favor of their mother, and respondent number 2 from 1992 itself. In this affidavit filed by the respondent number 2, he has not mentioned anything relating to separate possession of land by their mother and the respondent number 2 and subsequent issue of patta jointly in the name of the 2. The respondent number 3 has filed objection against the condonation petition of appellant.
Who is respondent number 3?
3 is the sister and her claim is through mother. Our claim is through mother, that the land should be settled in the name of mother. After that,
Why did you make the respondent number 3 a party?
No, she got herself
you
implemented. We did not, and court allowed
She's the sister.
sister.
Oh, no, sir.
And the writ petition,
Get me a pencil, not this colorful pen. Yeah.
she has stated that the respondent number 2, as the elder brother, honestly and in view of spirit of brotherhood, settled the land amongst the legal heirs of late Jogobala Majumdar, and the present appellant has got his share in the same. So she has further stated that the appellant had full knowledge and information
So
about
respondent number 3 was supporting the respondent number 2.
whereas her claim is that she gets, because mother will get, she will get from mother.
Okay.
Not
But
from
anyway, she is supporting the respondent number 2.
And
Okay.
she is joined in the writ appeal, in the writ petition.
Okay. Yeah.
And information about the
It
issuance
is
of a joint
important
patta in the name of Srimati Jogobala Majumdar and respondent number 2. The case records have been called for from the learned settlement officer so as to examine the same. It has been informed by the learned settlement officer that the same could not be found. The learned settlement officer has, however, sent his parawise comments. Another important document in this case is the letter of the Deputy Commissioner Kamrup number KRL 308638 dated 2/1/87. This letter has been annexed by the respondent number 3 with her objection dated 12/8/2010 against condonation petition of the appellant. This has also been annexed by the appellant in his affidavit in reply dated 16/8/2010 against the objection filed by the respondent number
So
2.
this document of 2187 issued by the Deputy Commissioner
Yes.
is available with everybody.
Yes, because the claim is by that only, Lord.
Because 87 was nothing has happened in the meantime.
No, what we felt is
No, because your thing, everything happened in 1992-93.
no, 87 that's why I said, Lordship, the district court passed the judgment in the appeals, and then the survey was taken up by the government, and government in 87, that is the letter of the Deputy Commissioner, and then the recommendation was the chitta.
Where is this document 2187?
That Lordship will find at 150, 154 of the memo.
Oh, yeah,
Annexure 19.
got it. 2187. This is written by the Deputy Commissioner Kamrup to the Secretary.
Yes. For
Yes. Let's read it. Humble submission is that an inquiry was conducted on the basis of the application submitted by the petitioner.
Yes.
Namely, so-and-so Dilip
Sure.
Majumdar, so-and-so Forest Majumdar representing the Vishnu temple.
it
So
was-
there were others. Jogabala was there, but you people were not.
No, Jogobala is the mother.
Understood? So
Huh.
Jogabala
Huh,
filed
huh, she
along
was
with the other three.
Other three. Other
So the-
Because
those
Lordship will
those are the
find that
persons, Jogaram
Jogobala
Gosha and all Forest.
one for
Yeah.
8 lesa was there. For Dilip Majumdar,
It was
5
found,
lesa.
no, wait. It was Dilip Majumdar was there. He was there.
Huh.
It was found that Jogabala Majumdar has been regularly paying the land revenue in respect of. Means this land revenue for 3 Katha 5 lessons was paid by everybody.
And they submitted some
Of bag number 489 of Kiraz Patta number 49. Now here 6. This is 6.
Hmm.
Since 1950. They have been enjoying the possession of the state land by raising their house. Was acquired by the have been in possession of the land in municipal further repeat the same. Jogabala Majumdar, one katha. It should be one
Actually, it
katha.
should be one kotha, Lordship. They have wrongly typed it as 4. Assamese version is
These
there.
are not typical typographical mistakes. They have not wrongly typed. They have kindly toned down both of you.
Okay, Lordship. The Assamese is at
Assamese
page 1.
vernacular is also given. Page
No, it's okay.
One katha.
It should be taken as one katha.
And settlement has been done in
On
favor
the
of the
other hand,
petitioner
Railway
broadly.
Department has informed that they had acquired the state. They have been repeatedly demanding access to the department. But the report available at this point, the access to the state. No such thing is also reflected in the report, which was submitted to the So the fact which emerges from 2187 is that though it was on one hand, he is saying that it is a Lakhira's Patta,
Yes.
which belonged to the Kamakya temple.
And again, that it is
Now, if it is a Kamakya temple land, the question of issuance of an annual Patta does not arise.
it will be as per the position, right?
Yes,
Right.
and
right.
once the land has been acquired by virtue of that 1959 Act,
Hmm.
under Section 3, the notification has been issued.
Hmm.
The land vests upon the government.
Yes.
The moment the land vests upon the government, your right accrues under 15 of the 1959 Act for getting settlement. So this is the manner in which it is being done.
Hmm.
But on the other hand, the question arises as to how can there be an annual patta?
Both the
It couldn't have been an annual patta issued in the year 1954 or earlier in the name of Sikha Basu if it is otherwise a Debatole.
Hmm.
So this could not have been a part of the acquisition proceeding.
that has to be clarified. That is why the
The-
court
That is why the board has given this.
that direction.
Because board runs contrary. If
And-
on one hand, if you are saying that this is a Debattor land and it has been acquired under the 59 Act, then obviously no annual patta could have been issued.
It should
And
be-
if it was an annual patta issued, then in that case it couldn't have been a Debattor.
That's why the name of the annual patta das were removed, Lordship. By
Now that
the-
is why they say that to remove this.
that is why. And
But
Lordship, what the board has said is
I have understood. Wait. I'm coming in 5 minutes. Huh?
Yes.
Then
Lordship, the
this letter has been annexed by the respondent number 3, page 217.
217. The respondent number 3 has filed objection against the condonation petition of the appellant in which he has supported the respondent number 2. She has stated that the
No, down below.
Uh,
This letter has been annexed by
uh-huh.
the respondent number 3 with her objection dated 12/8/2010 against condonation petition.
condonation petition of the appellant. This has also been annexed by the appellant in his affidavit in reply dated 16/8/2010 against the objection filed by respondent number 2. In this letter addressed to the Secretary Revenue Department, the Deputy Commissioner has forwarded the petition of Srimati Jogobala Majumdar and others for settlement of land, stating in it to be a land acquired by the government under Religious Institution Act. It has been stated that Srimati Jogobala Majumdar and others have been regularly paying revenue in respect of 3 Katha 5 Latha of land in Dag number
So
48.
tag number 489 pertains to annual patta number 6.
Then.
Yeah.
But when the order was passed, it was, they mentioned it
Let's
as
see what happened.
of Khiraj annual patta number 6, village Malika, Moja Jalupari, since 1954. They were stated to be enjoying possession of the said land by raising houses. The draft chitta shows that the land was earlier covered by a Lakhiraj patta standing in the name of Kamakya temple. This Debatar land was acquired by the government in 1971 under the provisions of the Religious Institution Act. The letter further states that the land records available show that the annual patta number 6 in respect of the land, Sri Katha 5 Latha of Dag number 489, stands in the name of Sri Manindra Basu and Srimati Shibika Basu. It has been stated that they never had possession of the said land, which is being occupied by the petitioner Srimati Jogobala Majumdar and others for almost 30 years, and they have been paying government revenue regularly. The possession of this land has been indicated in the letter as below. Srimati Jogobala Majumdar, 1 Katha 8 Latha, Sri Dilip Majumdar, respondent number 2, 5 Latha, Sri Joyram Rajbangshi, 14 Latha, Vishnu Temple, represented by Sri Paresh Das, 4 Latha, Sri Torun Das, application not submitted, 4 Latha. Total 5 Katha, 6 Latha. 3 Katha, 5 Latha. The letter has further stated that during Rayati survey of 1971, this temple land should have been brought under the purview of Rayati Khaitan and separate patta should have been issued in respect of the same. The learned Deputy Commissioner has stated that since the petitioners have been in occupation of the land since 1954, their names are recommended under the provision of Religious Institution Act for consideration of being allowed settlement in their favor. At the same time, the annual patta in respect of which there has been no possession be cancelled. The learned settlement officer in his parawise comment has stated that the land measuring 2/6 lesa covered by KP Patta number 38
Now this is
of
38
old 1 plus
and 119 now.
19 new, N means new, tag number 489 of village Maligaon under Jalukpari Moja stands in the name of Jogobala Mujumdar and Sri Dilip Mujumdar, wrongly written as Skilip, as per land revenue records. He has further stated that the annual patta belonging to Srimati Jogobala Mujumdar and her elder brother Sri Dilip Mujumdar has been converted to Khiraj Miadi Patta. Sri Dilip Mujumdar has been wrongly stated to be brother of Srimati Jogobala Mujumdar. Having examined the submission made by both sides and the available papers, few things appear odd in this case. A. The letter of the learned Deputy Commissioner dated 2/187, in which the settlement in favor of Srimati Jogopala Mujumdar and others has been recommended, giving a conflicting status of the land at that point of time. On one side, it states that this land is covered by annual patta number 6, which stands in the name of Sri Manindra Basu and Srimati Shibika Basu as per the land records available. On the other hand, it states that the draft chitta shows that the land was earlier covered by Lakhiraj Patta standing in the name of Kamakka Temple. Both cannot be true at the same time. Apparently, the land records that were available were more authentic, but the statement made in the draft chitta has been taken as true, and the land has been treated as a land earlier belonging to Kamakka Temple, which stood acquired under the Religious Institution Act, and thereafter recommendations were made for settlement of the same in favor of the occupants under the provision of Religious Institution Act. If this was an annual patta land belonging to private individuals, it could not have been made sarkari without following the required process of law for cancellation of annual patta. Thereafter, it could have been treated as sarkari land. Simply some remarks in the draft chitta stating that the land was covered by Lakhiraj Patta in the name of Kamakka Temple cannot make it Depotar land unless this was supported by the Jamabandi and other land records. The pattern of occupation shown in this letter of the learned Deputy Commissioner has stated that Srimati Jogobala Mujumdar was in occupation of 1 Katha 8 Lesa of land and Sri Dilip Mujumdar was in occupation of 5 Lesa. Recommendation has been made for making settlement in their favor. The parawise comment of learned settlement officer shows that an annual patta has been issued in their favor, which was later converted into periodic. It is not clear whether the annual patta was issued in favor of Srimati Jogobala Mujumdar and Sri Dilip Mujumdar separately or even the same was jointly. Since the recommendations of the Deputy Commissioner showed separate possession, it should have been issued separately in their favor, if at all it was to be issued. However, even if the patta was issued jointly, the land should have remained the same. The letter shows that Srimati Jogobala Mujumdar was in occupation of 1 Katha 8 Lesa of land, while Sri Dilip Mujumdar was in possession of 5 Lesa of land. The total of land was 1 Katha 13 Lesa as per the comments of the learned settlement office. The patta has been issued for 2 Katha 6 Lesa. This is the area stated by the appellant also. The respondent number 2 has in his objection dated 9/8/2010 against the application filed under Section 5 of limitations stated in Para 7 that this land is 2 Katha 13 Lesa. By making a patta joint, how the area of land could increase from what was found in possession of Srimati Jogobala Mujumdar and Sri Dilip Mujumdar by the learned Deputy Commissioner in the letter dated 2/197 is not clear. The learned Deputy Commissioner in his aforesaid letter has reported that Srimati Jogobala Mujumdar and others have been regularly paying revenue for 30 years. This statement strengthens the application for settlement in their favor. In a situation when the land did not stand in their name, it is not understood how Srimati Jogobala Mujumdar and others were paying land revenue. In view of the above, this case is remanded to the learned Deputy Commissioner Kamrum for re-examination of the settlement made in respect of entire 3 Katha 5 Lesa of land covered by tag number 489, for which he has sent his recommendation by his letter dated 2/187. So far as the present appellant and respondents are concerned, this order is been passed as part of this appeal. For all other persons who have been settled land therein, power are been exercised so moto under Section 151 of Assam Land Revenue Regulation 1986. The learned Deputy Commissioner, after examining all records and giving notice to all affected parties, shall take a fresh view relating to the settlement of land in respect of Srikatha 5 Latha of land covered by this dark number 489, for which he had sent details by his letter dated 2/187 and mentioned above. Apart from other issues, he shall specifically examine the following points: the status of the land at the time when the recommendations were made for its settlement on 2/187. If it was an annual patta land, which was wrongly known as Lakhiraj, standing in the name of Kamakha temple in the Drakitha, and thereafter action was taken to settle it in favor of the persons in possession under the provisions of Religious Institution Act, this would clearly be a case of fraud. Being a fraud, the settlement is invalid ab initio. The learned Deputy Commissioner shall proceed to cancel the settlement made in such a situation. All subsequent transfers would also be invalid. He shall also file a criminal case against all persons involved, including revenue officers. 2. The occupation of land by different persons has been clearly shown in the letter of the Deputy Commissioner dated 2/187, and recommendations have been made for settlement accordingly. In this, Srimati Jogobala Mujumdar has been stated to be in possession of 1 Katha 8 Letha of land, and Sri Dilip Mujumdar has been shown to be in possession of 5 Letha of land. If everything is found in order and settlement has to be given, it should be given separately accordingly. The circumstances should be examined as to how the land increased from 1 Katha 13 Letha to 2 Katha 6 Letha as per the statement of the appellant and the settlement officer, and 2 Katha 13 Letha as per the statement of respondent number 2. This appears to be a second element of fraud, wherein apparently a joint patta was issued to create confusion on the total, and a larger area has been settled than what was found in their possession and recommended for settlement. A criminal case may be registered on this issue also. 3. How the land revenue was being paid by Srimati Jogobala Mujumdar and others for more than 30 years without the land being in their name. The statement to this effect has been made in the letter of the Deputy Commissioner mentioned above to strengthen the case of the petitioners for getting settlement of the land from the government. The learned Deputy Commissioner is to complete this exercise expeditiously and in any case within 6 months. Till then, he shall pass necessary orders to the sub-registrar and others to ensure that the land involved is not transferred by way of sale, lease, etc. to anybody by the present patradar.
Now tell me, from the communication dated 2/187, there are two things which is clear. The petitioner herein was in possession of 5 letters, and the respondent or the Jogobala Majumdar was in possession of 1 Katha 13 letters.
No, 8.
One
13
Katha-
comes because
one Katha 8
adding
letters.
5.
1 Katha 8 letters. Now, if it is an annual patta, it belongs to those persons. Assuming that patta is cancelled, it becomes a government wasteland.
No, the houses are there. Huh.
Patta is cancelled, it becomes a government wasteland.
Hmm.
Then the government can very well settle.
Hmm.
This settlement will be then made in terms with the Assam Land and Revenue Regulation of 1 Katha 13 letter and 5.
1 Katha, 8 Letha, and 5 Letha.
Fine.
That we do not have objection to.
No, please. So then their settlement will be as per the settlement rules.
Whoever is in possession. Because others are also, other legal heirs are also in possession.
Wait a minute.
Huh.
It will be in the name of Jogobala Majumdar, 1 Katha 8 letters and 5 letters in the name of the petitioner.
Yes, yes.
So here the settlement will take the shape for settlement made under the settlement rule. Whereas, if it is a debuttor land and it was not an annual patta, then in that case, it will be a settlement made in terms of section 15
Of religious in.
as a landholder or a settlement holder, depending upon whether you are a riot.
That
were-
is why the clarification was brought, because of the
Therefore,
conflicting.
what the fact as to whether it was actually a devotor land or it was an annual patta land is required to be clarified.
That is why the point
That
number
is
one
why
is
that is the reason why the board have directed. Now that is one aspect. The second aspect is a patta which has been issued in favor of Jogabala Majumdar and him joint of 2 kathas. Your right to get the part of the patta
to the mother.
springs on the basis of inheritance.
Hmm.
Meaning thereby you are asking for part.
Maybe, or settlement, family
No,
settlement, or
whatever the settlement.
Hmm.
You can ask for partition. That partition you have to do either in the civil court or in the revenue court if you want to do it under section 100. And if there is an objection, the authority will refer it to the civil court. Or you can file a civil suit.
but there can be a family settlement, Lordship. That is the easiest thing.
Never mind.
Instead of
If
going
it
to
is
the
a
court.
family settlement, you can very well place the family settlement before the authority concerned
Huh.
and look here, this is the family settlement, and on the basis of that, the revenue partition will be done under 100. That is another aspect. But your right to claim a right on the basis of the patta which have been issued to your
No,
mother.
no, we did not claim. We said that the joint patta should be changed because her PA was 1 kata 8 lesa and his was only
You
5.
want less land.
No, not a question of less land or more land, Lordship. It is a question of doing the right thing. It is not a question of less land.
No, you want the total land which ought to be settled to have been 1 kata 13 land. In
No, but
favor-
not joint.
Well, joint, no joint. There might be a patta issued separately that can be also bifurcated at a later stage also. He can very well show that yes, 5 lesser is mine, so he will take it out. Another separate patta will be issued.
That
These
is
are all
what's not done. What they are saying again and again that we are in possession of certain land, but they have not bifurcated that. That is what is our.
it is not here the question of bifurcation. What is your claim? Your
Our-
claim is, as I could see from your IP. See, look here. My mother, the patta which should have been issued, should not have been issued solely on the basis of my mother and him. And after the death of my mother, it should have been also given to all of us. That is your claim.
Yes.
Your claim is not to lessen the area.
No. Our claim is that whatever mother got, that should be divided equally among the 8 legal heirs.
So it is a case of partition.
But before that partition, the clarification that the court has said, Lordship, that is to be, yeah. Otherwise, no problem. If there is a partition, if they agree to that, we do not have any problem. If we go for simply partition.
I have no thing. I have no.
If they do not
Family
have any
partition
objection,
Can be.
He would obviously not agree. He will obviously agree to it because the moment he does not agree, the amount of land will be reduced from 2 kata 16 lectures to 1 kata 13 lectures.
okay, I got it. Now I got it.
See, that is the reason why.
But my
So
reason
your
is
right-
not that, Lordship. My
So
reason
your right is not to challenge the patta,
but the joint thing.
or if it is in better words, the advice which ought to have been is not to challenge the patta, but to get a share of the patta.
For the mother's part, not his. 5 lesser, we are not claiming, Lordship.
No,
Let
I'm
him
not
have
on
it.
that. Madam, kindly appreciate or understand. Your claim should have been to get a share of the patta, not to challenge the patta.
Share of the patta through mother, Lordship. Not,
That is what I'm saying.
yes.
So you should claim that 5 letters is gone. So out of this 2 kata 11 letter, this area of land should be divided among the rest of the 8.
That's what before Lordship Bhuya because that day Lordship also raised this type
No,
of.
that should have been your claim. And that claim could have been made either before the Revenue Authority under 9900, saying that on the basis of a family partition, look, this is the amount. We are agreeable, and this is the amount which everybody wants to get. Patta has been issued, so let the patta remain.
No, that time we did not know about the patta. Patta came later on, Lordship. Because that time we knew only about that order. Like
You
we,
filed an appeal stating that about 2 kata 16 lessons.
no,
haven't
you got
you
a
mentioned?
6 lesser from the order, Lordship.
No. In the patta, you have mentioned that in your appeal. Kindly see 2 kata 16 letter. 2 kata 6 letter.
Yes, because that was revealed from the order. We did not
Okay.
have.
So 2 kata 6 letters is
Yes,
the area.
yes, Lord.
So 2 kata 6 letters, what should have been done by you is to ask for a share of it by filing a revenue partition. Or if it is not agreeable, file a civil suit asking for a share of it, being that you are the legal heir to the mother. But what you have done, you have challenged the entire thing
Yes, because
and created an unnecessary complication by which your land, which you were otherwise getting it, of 10 letters or 8 letters, reduced to 3 letters each. Isn't it?
but that was the right course, I suppose, Lordship.
Lordship, all legal heirs have been
Right
given
court.
position.
No.
Right course, then why you are fighting a litigation for last 20 years?
So, no, because Lordship, it should go. What our contention was that it should go to the mother.
You
And
see,
so
madam, the thing is like this.
I agree,
If
Lordship.
this court is going to pass an order on merits, this court is going to uphold it.
That
And
is
the moment I uphold this order, the settlement which has been made of 2 kata 16 letters goes.
yes.
But
I
the
got
fact
it.
remains that he will be entitled for 5 letters.
Yes.
Your mother would be entitled to 1 kata 13 letters.
Yes.
8 letters.
8 less.
And that would be at a later consequence. And thereupon, at a later stage, you may again have to ask for a share of it, which
Yes.
you should have done in the year 2001.
Lordship.
And getting a
Lordship,
much
one thing
higher.
can be done, Lordship.
Huh?
The parties, Lordship, will enter into a
Yes,
partition,
Madam Borua,
family partition deed.
you come now to the scene. Are you supporting the Board of Revenues or
Lordship, one annexure I would like to place.
no? Don't show me anything.
No, regarding Lakhita's position. It is with
Yes, what are you going to do?
a page, Lordship, and come to 176.
170.
176. Annexure number 20. The learned chairman of the board wrongly gave the fine.
No, he did not. He did not decide as to whether it is Lakhiras or not. He decided on the document up to 187, which was the recommendation made.
That
And in that document, it has been rightly. And what the learned Board of Revenue has come to an opinion is absolutely right. That you see, it could not have been a debuter land because what can be acquired? You can acquire only under the Religious Institution Act only the land which belongs to the debuter.
that is
But if it's an annual patta, you could not have acquired under the 59 Act. What would be the consequence is you have to cancel the annual patta.
annual patta, Lordship.
And if it is the annual patta is cancelled, then what you are going to get? It becomes a settlement under the settlement rules,
Government.
not under the 59 Act. Yes, madam.
Page
What
176.
do you want to do?
Just your Lordship, please to page 176.
170. Yes.
Lordship, this is a Kita is in respect of tag number 489.
170?
6. Annexure 20.
Yes.
Area of tag number is 489, Lordship. Area is 3 kata 2 letter. Number 1 Lakhita,
Hmm.
Lord.
Hmm.
Then Lordship may come to the 1, 2, 3, 4, 5, 6 column. On behalf of Kamakhya Temple, Premnath Sharma Doloi. Number 3, Manindra Basu, Pinky Basu, late Tarani, then Shukla Majumdar, Dilip Majumdar, Jairam, and Raju. So it was, this document was before the Board of Revenue, which clearly proves that it was a temple and Lakhiraj lot. So giving the finding by the board that it is, if it was not a.
No,
it
no, no,
was-
no, 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 no. What you have not done is this. While putting out this at page 176, you have not strike off. You see the vernacular. This on behalf of the Kamakya table, Pramanath, the Sharma Dolo has been struck off. And the name of these persons have been inserted. Kindly see 179.
My copy is not here. My copy is not there.
Whose writ petition it is?
Ah.
Whose writ petition it is?
It-
Then?
The court copy is quickly.
Yes,
My
Mr. Roy,
copy is-
don't make
my
these
copy
type of
is-
submissions again.
As because Lordship, they were not found in the position, that's why their names were struck. That observation has been given by the chairman of the Board of Trade. They were never in position of the.
No, no. Whether they were in possession, no. The Board of Revenue did not decide on that. The Board of Revenue decided on the communication dated 2187, wherein it has been, which is the recommendation for getting the settlement.
Yes.
And
But-
on the basis of which you got the settlement.
But in the Parawai comment sent by the DC or SO Lordship, it is clearly mentioned that their names of Basu and others who were struck off as because they were not.
No, no, they were struck off. It's okay. It couldn't have been struck off. It had to be cancelled. So the debutor land was struck off. It was no longer a debutor. If you see page 179,
But Lordship, if it was noted there was how
Huh?
the government, if it was noted there was a land, how the government acquired the land under the Act of 1959 in
no, 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 no.
1967.
No, what the government does, government issues a notification that these are the dogs we are taking over on the basis of this is the land which I am taking over under section 3. That the government does. But if it is not a part of the debutor land, section 3 of the 59 Act has no value.
No, Lord.
No,
The
tomorrow
land was
in
acquired
tomorrow's
under-
land,
land
in
was
tomorrow, let us assume Bhutnath is a religious institution property. And nearby is your house. And your land is being inserted. Would that notification hold any value against your land which is nearby? No. Because it doesn't belong to you, the debutor land. So this what has been done is this.
I am having the Lakhiraj Patta, but I have not annexed.
Very well. Hello, let me dictate.
Lordship, then we can look into that suggestion Lordship made. The
Lordship-
legal as can look into that aspect.
I will do one thing only best.
Yeah.
I will only tone down what has been directed by the
Chairman.
by the chairman. Otherwise, whatever he has asked for is right.
Yes, that I agree, Lordship.
But
Then
the only
Lordship
thing
saying
is you
that-
have opened up unnecessarily a Pandora's box.
So that is why, Lordship, if they are
And
agree-
because of that order, it can't be settled. Unless the government comes up and says, then look here, we are okay with this settlement, which they can't. Are you in a position to say no? She will obviously say no.
The Lordship, an opportunity should be given to the party. Within-
Absolutely. That is how I am going to tone it down. That is how I am going to tone it down. Otherwise, it is not. I'm giving you an opportunity. Whatever direction is given is there. I'm not going to touch it. But only that I'm going to tone it down, thereby giving an opportunity to both the parties to address and place it before the deputy commissioner, so and so. Until then, the status quo as on today, till the decision of the deputy commissioner is done, shall remain. And the deputy commissioner shall do it within a period of 6 months.
Lordship, my humble submission is this. In spite of that, Lordship, if the parties are allowed to enter a petition and they will file it, then they will take only 10 days and will file a compromise petition or a deed of petition. Because already shares have been given to all the legal heirs of Yoga.
Shares given of what? A thing which does not exist.
Now, until and unless the Lordship, the patta is cancelled, they have the concluded right. Until and unless the patta is cancelled.
No,
They
your
have the
patta is
concluded right.
cancelled means patta is not cancelled till now.
That's why, that
The
is my
patta,
submission.
no, it is not cancelled. What has been done is this inquiry will be carried out, and on the basis of which the patta would be issued.
Yes.
Would be issued depending on taking into account this 2187.
Lordship, my humble submission is both the parties can file a petition.
I cannot. Because she has opened the Pandora's box
It is a
unnecessarily.
petition, Lordship, relief can be molded.
I can't mold the relief. Tell me, how can I mold the relief when the others are not the parties before this court?
The parties who are not before the
Not,
court-
not your relations.
No, they
Those other people are not
yes,
before the
Basu
court.
and
Yes, then,
Manindra Basu and
not Moninder Basu.
Rajbangshi.
The other Rajbangshis and all, they are not parties. And that is why, you see, this order has been properly made. That is why he exercised 147 in respect to both of you, but 151 in respect to others.
for issuing
Yeah.
notices, this and that.
Writ petition disposed. I'll pass the order, you get record. I can only tone down whatever he has said about criminal cases and all. I'll give you an opportunity to address, and you may be more successful in explaining to the deputy commissioner to get a relief more than what you want, but not this court. And I'm not referring to all this unnecessary judge.
And the other.
And the
case-
other one, what is this? Have you paid the 2,000?
Uh,
You have made constructions?
Yes.
What is that?
No. Construction was made before it. Lordship, the Board of Revenue granted a status quo. Only. In respect of what, nothing is mentioned, most vague of it. And Lordship is aware regarding the judgment of the Honorable Justice Jain Sir. So until and unless it is specified regarding what Lordship.
When it is mentioned as status quo, it means status
It's not, so I had filed my affidavit in opposition before the board, denying that whatever construction I did, it was done before passing of the status quo.
No,
And
the
in the
permission
status-
itself we
let-
got
let
in
me- let me
2009,
complete, madam.
Lordship.
And Lordship,
Huh?
while
When was the status quo order passed?
Lordship,
Status quo order passed?
status quo order was passed, Lordship.
It will file.
Status-
It is taken to him. Where is the status quo order?
Yes. Yes, Lord. Page 148.
Yes. Status quo shall be maintained by the parties as on today in respect to the land in question till the disposal of the appeal. Then, what else? You
Lordship, in a contempt proceeding, Lord, under the contempt act, they had to adduce the evidence. Nothing has been done.
No,
And
no.
penalty of found guilty, finding in this that the petitioner number 1 is found guilty and penalized 4 rupees.
Is it?
That is the order. Impugnated. Without taking evidence, a contempt proceeding cannot be. And already the contemptor has expired.
Who?
Dilip.
But if it is expired, what is the consequence?
They substituted the legal ad.
Legal, my learned friend has filed an application law.
No,
No, sorry,
in-
I had also filed it.
Then why did you substitute?
It is legally.
Why did you substitute?
No, in the, I substitute in the writ petition.
Why?
in both.
No, why? Why did you substitute here?
In
The
both.
right to
Two
sue.
IAs are there.
That is, imposing a penalty lordship without taking evidence, without evidence.
The instant writ petition has been filed challenging the order dated 14/3/2011, passed in case number R number 1 RA bracket CONT bracket close bracket K oblique 10, whereby the learned Assam Board of Revenue found the respondent number 2 therein, that is Dilip Kumar Mojumdar, bracket since deceased, guilty of contempt of the board, and accordingly punished him with a fine of rupees 2,000 as per the provisions of section 12 of the Contempt of Court Act 1971. Being aggrieved, the said late Dilip Kumar Mojumdar, being aggrieved, the late Dilip Kumar Mojumdar had approached this court by filing the instant writ petition, stating contending inter alia that a perusal of the impugned order dated 14/3/2011 would show that there has been no application of mind by the learned board of Assam Board of Revenue in coming to a finding that the petitioner, late Dilip Kumar Mojumdar, was guilty of contempt of violation of the order dated 4/12/2003. It appears from the record that this court, by an order dated 3/1/2012, issued notice, and in the meantime, state the operation of the order dated impugned order dated 14/3/2011 First. The instant proceedings thereupon has been continued. It is an admitted fact in the bar that late Dilip Kumar Majumdar expired on
8/6/20.
Hmm?
8/6/20.
8/6, 20,
2023.
on 8/6/2023. Under such circumstances, as a contempt proceedings, as any sentence in a contempt proceeding is personal to the person who have violated, a person who have been alleged to have violated the orders passed by the court. It is the opinion of this court that the instant that the order dated 14/3/2011 had become infructuous, had become redundant in view of the death of late Dilip Kumar Majumdar. Accordingly, the instant repetition stands closed with the above observation.
Apply.
Highly obliged.
But the other one, your land is going.
They are even family members, Lordship.
Huh?
They are all family members, Lord.
Can't help it. The problem arose because she opened it.
He opened the Pandora box, Lordship.
You should have settled then and there.
Yes. So
Why
I,
were-
Lordship,
Instead of
tried-
fighting out there, Mr. Roy, you should have settled it then and there.
Lordship, many times I try my best to.
No, Lordship. That is again not a fact. So,
No, not necessary.
Highly
But
obliged.
this is the problem now. You'll have a big problem.
And board does not, Lordship, regarding violation. Board does not have power to grant any injunction. It has power only to suspend the impugnment. Only to suspend the impugnment in a contempt, Lordship. If an order is passed, status quo order, there is no provision in the Assam Land Regulation Law regarding granting of injunction.
Item number 1, part
Only impugned order can be suspended.
Yes,
My lord, I
where is Mr.
received-
H. Sharma?
my lord, he is in another court, but my lord, I have received, my lord, a letter that the duplicate copy could not be traced. It was not prepared properly, and duplicate copy could not be traced, my lord.
No, we have asked for the records.
Records, it has come properly,
Has
my
the
lord.
records been called for?
Call for, my
আইছে নেকি কিবা? আইছে নি? ওই যে। ডিআরও কেস এইখন আইছে নি?
Yeah. my lord, if presence of H. Sharma is required, my lord, then I'll call him,
Yes, his presence is required. This matter has been heard.
my lord.
No, without the case diary, how am I going to look into it? And if
My
you
lord,
don't
sorry,
give the
I-
case diary, the burden lies on him.
I have received the communication, my lord. An inquiry was conducted, my lord, by
What convenience?
additional,
How can you
Assistant
have
Commissioner of
more
Police, my
the
lord.
second or third CD?
my lord. That, my lord, I have received a communication, my lord, today morning. The communication.
This is only the orders being passed. Where's the CD?
That city,
We are concerned about the 2016. You can't find out the records.
my lord, because of shifting of my
Yes.
lord, because of construction of my love new building.
You see, madam, where is Rishikesh?
My love, I've told that he's.
Yes, Mr. Sharma. This shows that you have not been able to trace out the case diary.
Lordship.
Now, here, as I have stated, informed you on the last occasion,
Lordship.
the case diary does not form a part of the evidence.
yes.
So it would not be kept.
Yes.
At the time of disposal, as per the criminal rules and orders, this has to be returned back.
Your Lordship, as I have inquired with my colleagues, Lordship, it is the case there is given to the public prosecutor. Most probably after disposal of the case,
You must have shown
but even that Lordship, the duplicate
can't-
and duplicate should be there in the office. If it
So
is not found,
they are not being able to find out.
in that case,
No.
Lordship may pass the order in accordance with law, Lordship, as because we
No,
are
no, because unless
regarding that.
this is not there, the burden in view of that judgment of 95, the burden lies on you,
Yes,
and you have failed to research.
yes, yes, Lord.
This court, this court have
It is yes, knife one.
had by the order dated 28/9/2023 directed the learned counsel appearing on behalf of the state respondents, Mr. H. Sharma, to produce the duplicate or the triplicate copy of the case diary so maintained before this court in respect to Panbazar PS case number 435/2016. Today, Mr. A. Sharma has placed a communication issued by the Assistant Commissioner of Police, Panbazar Central Police, wherein it has been mentioned that the duplicate and the triplicate copy of the case diary could not be traced out, and the triplicate case diary was not prepared. As regards the original case diary which was submitted before the trial court, it is also the submission of Mr. H. Sharma, the learned counsel appearing on behalf of the respondents, that the trial court, pursuant to the disposal of the said proceedings, have returned the case diary to the public prosecutor, which could not thereafter be traced. So, taking into account the above, this court, therefore, having heard the matter at length, reserves the judgment
Lord.
As because regarding that part, if we are unable to place it before your lordship, in that case, lordship will follow by that 2015 judgment, lord.
To 1995.
95 days.
95. No, that is why I gave you an
Lord-
opportunity.
Lord-
The document which have been placed by the learned counsel for the state respondents is kept on record and
Lordship.
marked with the letter X. I'll deliver the judgment. The judgment is ready.
Lordship.
It's come up. Only thing is, I wanted this because without giving an opportunity
Absolutely.
tomorrow, if I pass that order, it may not look proper.
What is the situation
I'm
arose
with
for handcuffing the person, lord? It is better. Much obliged. I'm sorry, lordship, I was then.
At number 18,
Yeah, I don't know, 295. Oh, yeah. Which one is this? Oh, that one.
5% and 10%.
Oh, yes, 5% and 10%.
My lord had directed the private respondent to file an affidavit.
Have you
They
filed
have
it?
filed yesterday. Well,
Lordship, we have filed an affidavit. It is on record.
Hmm?
We have filed an affidavit.
Where is it?
It's on record.
What is your status? Mr. Counsel for the petitioner, are you in a position, just for example, this court or taking into account the if in this court interferes with the order of the respondent number 7, are you in a position to do the work at the rate which you have done it? Because 2 years have already passed by. 2 years. 2 years have passed.
Lordship, as per information gathered from the respondent, he has done the work, then there's the task. In spite of status quo granted by some. So at that point of status quo granted,
That status quo is not clear. It only says that the status quo. Status quo as on that date it was given.
or work order issued on 12/7/2021, lordship. And status quo granted on 13/7/2021.
That I've seen it.
Certainly it has done after that. It should not have done the work.
I have
lordship.
to inform you that the informative
Since he has done, he has to follow the consequences.
আপোনাক যিটো সুধিছে সেইটো কওক না আপুনি এটা কৰিব পাৰিব না কাম
Yes,
আপুনি নোৱাৰে
Yes.
আপোনাৰ লাইচেন্স নাই
and I am ready also, lordship,
ready or
ready to accept the work
at your price.
at my price.
You're ready. Now you have seen the affidavit.
Affidavit plus the IFC. They have plantation they have done
So the plantation part is complete.
complete.
So
I will
you have to maintain.
I have to maintain, and since he has plantation done, I will pay the expenditure.
So you have received any money?
No.
He's going to pay you. You hand over the work to him.
My lord, he cannot proceed with the work because, my lord, technically, my lord, his license was expired. And now a situation has come up very strangely. This is only the sole project which is under scrutiny. Otherwise, my lord, there's a policy decision, my lord. No plantation will ever awarded to any contractor, my lord. It will be done by the department.
This is still continuing for 5 years.
Yes,
This will finish in 2026.
27.
He has not got the
It's
money.
up to
He's
lordship.
going to
If
pay.
He's willing to pay.
He's willing to pay.
It's up to lordship.
You pay him.
Yes.
And give him the contract.
If he's If he is,
I'm reimbursed for what I.
if he's reimbursed at his cost,
No, he must have given his bill for that.
yes, Lordship will see that security money has deposited.
Huh?
Money, no, plantation.
Plantation was security.
No, this is a different thing.
Yes, sir.
This-
The plantation, he will reimburse, but
The
at his risk, madam.
Huh?
He will reimburse. It is Lordship will.
No, what is it? You must have raised some
Yes.
bill. What is the bill? You have raised?
Bill can raise call, bill. Bill can I? Bill नहीं. Bill there नहीं. Well, bills have not been raised because this was under sub judice matter. So bill has not been raised. Only the work is already completed.
So then I will assume that the status quo was operating, so he should not have planted anything.
One issue, my lord, there was a special
No,
circumstance.
anything he has done, I have already passed an order earlier. A final opportunity is given. No, here. It made clear that any work so done shall be subject to the outcome of the repetition, and the respondent number 7 cannot claim any equity on the basis of the work so
Yes, sir.
done. It's further that no amount shall be released to the respondent till the next date. Now he has not raised any bill. So under such circumstances, whatever he has done, you find out some other area, you give it to him. Or I set aside that. Why should I give it to anybody? Set aside it. Holding it to be illegal, set aside it. Do whatever you like. Is your lookout. Because you have done it illegally.
No, my lord, what had happened?
No, there is nothing.
There is preliminary work order was offered to him.
Forget
Special
about the
sur-
preliminary work order. You see, the order was passed on 12/7 to
12/7,
proceed,
Yes.
and on 13/7 there is a status
Status
quo
quo,
order.
Yes.
So thereafter, if you have proceeded and he has done it at his own risk.
Unless I was put to notice, my lord, of that status quo
Huh?
order. Unless I'm put to notice of the status quo order. it cannot be
No,
put
you
to
did
notice.
not complete it. You appeared when? When did you appear before this court?
I
And the status quo where you appeared and you filed your written state on
That's
16th of August 2021.
Yes.
So you filed your affidavit in opposition on 16th of August 2021. Then what do you mean?
What
Nothing.
What preliminary work order was the when I was given the preliminary work order, it was by that time immediate after my work
24th of August 2021.
Yes.
And you appeared for the first time before this court on
I filed my work order. Let's take it over. By that time the
and the forest department having not informed you, file a civil case against him.
No, we
Because
had
the forest
informed-
department was
we
very well
had
represented.
informed. We had also written letters, instruction to receive, my lord. Status quo is informed to them. What had happened?
What was your instructions to him?
No, not to him. We don't know him. We passed. I was present in the court. We
No. After the order of status quo
Why
being passed, what did you do?
We maintained status quo, my lord. In this
How?
particular circumstances,
No, what did you maintain status quo?
my lord, it was that work was not proceeded with. Work. Huh?
the work order is already there. Status quo.
And
the
did you
work
inform
order
him
exists.
about the status
on
quo
that.
order?
No, we didn't inform. He was hired. That part, my lord, he was not informed.
Did you communicate to your officials?
Yes, officials are coming.
Then what happened?
And then my lord, status quo was, my lord, since our work order is already out, my lord. And
So?
my lord, what had happened? By preliminary work order, my lord,
Hmm.
official circumstances, this respondent had a huge stock, my lord. Huge stock already was there with him.
So what?
So he already planted, my lord.
So what?
Maybe
You-
a portion.
How does it matter? Till the next date, status quo in respect to the contractual job.
Job.
Meaning,
By,
as on date, whatever has happened, has it.
Yes.
You have to maintain as it.
by 13th, my lord, he moved the
It
court
was
to
not
13th.
a simple status quo. It was a status quo as regards the contractual job. Means you stand as it is, a statute. You can't do anything. Shall be maintained as on today. And the interim order has been continuing.
Yes, it's
So under such circumstances, if he has done so,
no, my lord,
Prior to my notice.
prior to his notice, my lord, prior to
Prior to my
filing of that
notice,
case, 13, my lord, most of the plantation was done.
So that that matter has to be taken up as to what portion of work had been completed by the time the status quo order was issued.
Have you mentioned?
I have not mentioned it date-wise in the affidavit.
Huh?
I have not mentioned it date-wise in the affidavit.
Then, when there was a status quo order, it was the bounden duty of you to inform. And when the forest department was very much present,
By 13 and my lord, by 14.
13/7.
My lord, by 13/7. 13/7, my lord, preliminary work order was there.
preliminary work order, the work to proceed was on 12/7.
Work to proceed, my lord, it was completed by, my lord, a substantial amount was completed till we communicate, my lord.
No. The notice to proceed was on 12/7.
12/7.
Okay.
Petitioner comes
Notice to
court at
proceed
13,
was on
order is passed,
12/7.
my lord.
The status quo order was passed on 13/7. Then 13/7.
Yes, sir.
Then the next day itself. How can you say all these things you don't know?
Preliminary work order was passed, my lord. The contractor proceeded substantial on that preliminary work order.
Here it will be on the basis of notice to proceed.
Proceed.
Notice to proceed with the work is given here on 12/7. Kindly see. Pursuant to you furnishing the requisite security and signing of the agreement, so and so, of rupees so and so, you are hereby instructed to proceed with the execution of the work in accordance with the contract document within 7 days after the date of issue of this notice. Within 7 days after the date of issue of this notice. So he has to start only thereafter. And this communication was issued on 12/7. When did you receive it?
The agreement is signed on 12/7, if I'm not wrong. The copy of the
Order of status quo is on 13/7.
after 12/7, I have already entered into the agreement matter. 13/7, this honorable order passes an order. When did I receive the notice?
I'm not concerned about the notice. He knew about it. The forest obviously means that he was present.
They were present.
So they should have informed. If you have any loss out there, you can ask him. This is on the basis of violation.
আমি পঠাই জনাইছো না এই জনাই ক্ষেত্ৰত লেটাৰখন আছিলে
And in your affidavit, which was filed on 24/8,
Yes.
you have not stated you have completed the work.
Any part of the work is left out.
You have not. Wasn't it required for you? Wasn't it required for you to do so?
Challenge me to not to my completion of work.
No.
The amount
The
of
challenge, no. You want to get any benefit. You want to get any benefit out of it. That this court should not interfere because of certain work have been done. Then on the basis of that, you should have. Hello. I'll pass the order allowing the petition. Set aside this.
my lords.
Setting it aside. Get the order
Live.
disposed.
At number 2, for admission, pardon.
But in this case,
Hmm.
there is a direction from this board. 10/10/2023.
Hmm.
Pursuant to that order, they have filed an affidavit which we have received today
Hmm.
morning. And from this affidavit, it appears, my lord, that the annexer they have made a part of this affidavit was not of the original record. Because the paragraph 2 of this affidavit, page 90,
Because the records have been called for.
Records been called for, the records
In
also,
these records, that application is not there.
That-
Have you looked into it, Mr.
Sure.
Bothakot?
Sure.
It's not there.
and also, my lord, apparently in the paragraph 2, they have admitted that it was not with the original committal code, my lord.
Huh?
Original code, my lord.
Huh.
It was not there. So they could not obtain the certified copy. So they made a prayer to the court, trial court, to bring it on. Then the trial court passed an order to bring it on fresh
Okay.
from the police station. Accordingly, from the police station, the annexure has now come up to the court and they have now annexed it as a part of the record. That what will find out. The first logic will see the paragraph 2.
Of the additional affidavit,
Yes, which has been filed today, my lord.
but this court had directed me to produce the certified copy of the communication.
Now, page number 105, my lord.
Oh.
Same affidavit, my lord.
Yes.
Now, this is the copy, my lord, which has been seen by the magistrate now on 19/10/2023. So, this document has been introduced now to the court. So, originally, admittedly, it was not there, along with the FIR.
But how did the police give it?
That we got.
No,
Where from?
when the court passed an order,
Yes.
how did the police give it?
Don't know. That's the enigma, my lord. Because if it was there with the court, why they have not sent it with the FIR? Because when it was registered, they would ought to have been sent it with the FIR to the court concerned.
And
That-
also at the time of filing the charge sheet.
Or at the time of filing of charge sheet. Neither of the time it was not sent to the trial court. Charge sheet has been filed. There is no record of that particular group. Initially, it was not put in record. Now they made a prayer informant. Then on the prayer of the informant, court passed the, as per the affidavit, that order is not available in text. Then the court, the police, whether these orders are not available, how it has come to the court, what order has been passed by the court, and how it has come to the police, why the police has failed to provide that document initially. So this document has been now, it has been seen and part of it. After the 8 years, this document has arrived to the court. Why it is not part of the search? It ought to have been part of the search sheet. It has been available at the time of the right, or it could have been a part of the FIR.
Now the charge sheet has been submitted. That is the recent judgment.
Yes.
When a charge sheet, the FI can still be looked into.
Yes.
Where is the judgment? Kindly come, Mr. Bora, kindly
Fine.
come to paragraph 4 of the judgment.
Yes, ma'am.
So don't you think that there needs to be a, it was done here and that was detected for which the matter went? Some form of challenge by way of a case or something to the charge sheet. Because what happened, I cause the FIR tomorrow, the charge sheet remain, however,
So we have to, yes.
because otherwise it will
We have to file an IMR to
not
challenge.
it has been done.
And I'll keep in the meantime, when the charge sheet is filed, the option is available for my client to challenge that before the appropriate other that court also.
It could, it would have been better. You
It
challenge
is
it, because
better.
why we,
Yes,
the problem which we have, the court is facing, I'm handicapped because I don't have the state of Jharkhand here. Now, if the state of Jharkhand was here, I could have very well put it out there and ask them how this would have been possible if it was the state of Assam here. How could you have done this?
Yes.
I'm not in a position
Yes.
to do so without the state.
Correct.
What do you propose?
I'll take some one time. I'll take the
Give the
instruction from
instructions for this, because
okay.
barely challenging the FIR now would have no meaning, because it has
Yes,
already been
becomes
taken.
charge sheet, we can challenge it again once again. But we are on a mistake, but I think that could have been done on before the Bukar report or Jharkhand.
Okay, we'll have it where
After my Diwali,
only
10
to
days, but
have it
10 as far as the convenience.
21st of systematic three. That is the paper for a period after can obtain instruction from his client as to the further course of the file.
How like?
At number 3,
Yes,
The last of it.
Yes, Lordship. As regard the cancellation of annual pata and unveiling it, the instruction has been sought for with regard to the records.
yes, madam, what was the case about?
My annual patta was cancelled.
The annual patta was
Cancelled without
auction? Cancelled?
cancelled.
How is it?
Without
Your rule upon the amendment should not be authority to accept the revenue so and so.
just 5 days. In the executive, they
I repeat the respondent to settle the appropriate Then you were having an annual patta. So what is their stand?
Annual patta, it has been cancelled because non-payment of revenue and government orders are there as regard enrollment of that annual patta. And
Have you issued notice?
for that matter, Lordship wanted to have a look at the record. It is with regard to 2019-72. So we have sent the communication based on the last order, but that record could not be traced out. And as regard their queries, whether it has been auctioned, that has been replied to in the RTI reply. That RTI reply says there is no auction, no acquisition, for which notices, question of issuing notice doesn't
Huh?
arise. There was a question as regard whether it has been auctioned to some other person.
No, forget about auction, no auction business.
Yes.
Auction, you have to do it you have to put it on sale as per 72.
As regard,
I'm not on that. I'm only on a very simple thing. You cannot cancel the patta.
without it. Very simple.
Didn't? What do you say?
Put that
1951?
another 1999 one year.
That is PG Agarwal? You got many judgments? Give me one of it. On renewal notice, yes, 1950. An annual patta RTL it is either cancelled or notice of renewal given to the patta holders by other than that is that he can take it. Since when have you not paid your land revenue? Because you have woken up in 2018.
For the last few years, before 2008,
Since when? Show me your land revenue receipts.
10 million.
Huh?
Not 10.
So you must be having it. You must be paying it. Fantastic. You bring on record. And what is this annexure 2? 144 proceedings against somebody else. Then only you came to learn that the land does not belong to you. Huh?
And the
Okay.
government has refused to accept the revenue mill. Then I made an entry.
So when they have refused to accept, so most probably we must be paying the revenue prior to that. When? Now, the learned counsel appearing on behalf of the petitioner. is directed to file an additional affidavit bringing on record that till when the petitioner had paid the land revenue in respect to the plot of land measuring 8 bighas, 2 gata, 3 lechas covered by dag number 172 new, 243 old, or patta number 9 new, 10 old under Mozak Kachmari under Nagaon Hodor Revenue Circle in the district of Nagaon Sam. Further to that, the respondents are also given another opportunity to produce the records pertaining to the cancellation of the annual patta proceedings of the petitioner. This is the matter again on 18th of December, 19th of December 2023. The affidavits be filed by 13th of December 2020. You merely stating no, bring some document till when you
At number 6,
This is as directed by this honorable court, my lord.
Hmm.
The deputy commissioner has filed the affidavit.
what is the matter about?
My lord, the petitioners, they are claiming compensation on the plea
Oh,
that-
that,
that-
that land by which you
my-
say that you have not
Yes,
acquired.
yes, that is. Your lord, you may take it up next week, my lord, for disposal, because today they are also.
This is the affidavit
By-
which has been filed on 22nd of September
Yes,
2000.
yes, deputy commissioner,
District Commissioner Morigaon.
yes.
So, Mr. Gustami,
My
from this long affidavit,
My-
giving various details,
details. my lord.
short question which
Yes.
is involved is as to whether you have taken any land of theirs for the purpose of construction, for the purpose of acquisition.
Yes.
But you
That
have.
is the question, my lord, issue involved here, my lord.
Yes.
In fact, for raising and strengthening the present, my lord, embankment, my lord, the existing embankment, this scheme was executed, my lord. That is why, for the execution of the present scheme, no land was acquired extra.
So there were certain lands which were acquired earlier,
1960, it was,
1960.
my lord. At that time, my lord, all the petitioners were, lands were also not written in their name, my lord. Other people were there.
So then, but their land was acquired at that point of time.
Perhaps, my lord, no record, because that time, my lord, Morigao, this district is also not there, my lord. 1960,
No, but there is no acquisition proceeding.
yes.
Are you using the petitioner's land?
My lord, partially, as per the affidavit file, my lord. both
Yes,
parties.
that is
Yes,
what-
partially, my lord, the embankment touches some, my lord, dark numbers.
Of the petitioner. Now, if some dark
This is
numbers
the,
of the
this is the
petitioner,
existing, my lord,
no, if the embankment touches some of the dark numbers of the petitioner,
my lord.
don't you think that some acquisition proceedings has to be done?
My lord, that was 1960. That is
No,
why it is,
maybe,
Fine.
whatever may
there is
be.
no record as such, my lord, available, whether this was acquired or not.
So what do you propose to do then?
That is why, my lord, they are claiming compensation on the plea that this scheme that has been executed now, for that, my lord, land was acquired. This is not correct.
But not on the earlier one.
This is not a new scheme. Only
But
existing.
if their land have been taken over,
My lord.
and you have no records as to whether the land has been acquired.
Yes, during 1960 or not. Whether in the office of the, my lord, deputy commissioner, or in the administrative department. Earlier, my lord, even the works department, there was only work department of PWD
Hmm.
during 60.
Will not be paid the compensation amount for acquisition of land for construction of embankment for students. So this, now your specific stand is that you have not acquired any land for this project.
Yes, no. Yes,
Where is your stand in your affidavit?
yes.
Where is your stand in the affidavit? That paragraph. The very complicated. Kindly come to paragraph 4.
Yes, that time. Paragraph 4, my lord.
The
page
deponent
40.
states that there is no record as available in the office of the deponent towards acquisition of any land as referred to by the petitioner for construction of this.
My lord.
As per the report of the executive officer, the areas in the requisition fall in the left bank guard embankment where raising and strengthening works were taken up under the scheme mentioned above over already existing embankment
Yes.
on the left bank of the river Kupili at Dokhin Dharam.
Right.
It is relevant to state that the embankment in question is partially under the land of so and so, so and so, so and so. Clearly, the embankment is there over the land bearing number so and so. With a view to find out the actual state of affairs. So, these are dark numbers or patta numbers.
Yes.
Problem arises with so many petitioners together.
Yes, so many petitioners are there, my lord.
In which petitioner, in which land, it is not known.
Yes, tag number 28, partially touch, tag number 193, tag number 14, tag number 34, no. Dag number 300, no. There is no dag number SS 519.
No, here if you see paragraph number 2 of the receipt.
They have.
Huh?
Here, that is why your lordship directed to file
No,
the
no, no.
affidavit.
There are
Best.
two parts. First, you see,
My-
covered by length of dark number 28 of patta number 224.
My lord.
28 of patta number 224.
My lord.
Dark
No, that-
number 193 of patta number 105.
My lord.
Then dark number 34 of patta number 154.
This is correct.
It-
Oh, this is not correct. Sorry. Dag
Okay.
number 34, not that.
So as regards these two lands,
My lord.
dark number 28 of patta number 224, dark number 193 of patta number 10, number 14 is where 14 is there. Number 223.
Dag number 34, no.
Number 6. 6 of 12.
Yes.
6. Dark number 27.
Yeah, but-
So
Right.
these persons, so these dark numbers, there has been some equation.
No
use,
equation, not as
but
per
you
the
have
record.
to
Yes.
use.
The
Dark
embankment.
number 28 of pattern number 224,
Right.
dark number 193 of pattern number 105, dark
Yes.
number 15 of pattern number 223, and dark number 6 of pattern number 151.
Correct.
So these are the lands where there is, and you have specifically denied as regards the other lands where you have not used it.
The embankment has not touched.
Not. So here, or the project has no relation with those.
Yes,
The
no,
other
no
lands,
relation.
except these four. 1, 2, 3, 4.
Right.
So these four, if those belong to the government, these people land,
There also, my lord, mutation was done at a later stage because even their name of their the petitioners were not in the records of them. That is also stated in your.
now how do you take care of these people?
My lord, that is why, my lord, we did not know.
Now
Even-
understood,
Yes.
without knowing also,
Right.
can you remain in possession or take over somebody's land if it is, you
my
can't?
lord, since 1960, there was no objection. That was the
Objection or no objection, but
Right.
can you take somebody's land?
cannot.
So the constitution
that time,
still,
whether we are-
1960
Yes, yes.
constitution was there.
No, but
And
at,
I
the-
think
at the relevant point of time, my lord,
and at that point of time, it was a fundamental right even.
that is not denied.
No. At that point of time,
Right to property.
it was a
Now,
fundamental
now
right.
it's a constitutional right.
Now it's a constitution. So what do you do? What do you propose to do?
Propose, my lord, they are, my lord, praying for a direction for making payment of compensation against the scheme in question. But the present scheme is not the new one. This is only a scheme executed on the existing scheme that was constructed way back 1960.
But give me a manner in which both parties can be duly taken note of care.
That is the difficult.
Something has to.
All right,
We'll have
next
it
week
next week.
my lord, we'll see.
We'll have it on 16.
16.
You just think about what
Yes,
can be
yes,
done.
yes.
List the matter again on 16, taking into account that the counsel for the petitioner is not present.
I'm present.
No. Your name you will put it.
Right.
But you and Mr. B. Goswami, the learned additional advocate general, shall also, government of Assam shall address this scope on the issue as to what steps can be taken in respect to those land which form a part of the project.